Good afternoon, everyone, and welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP, and we're here to take any questions you have. If you're tuning in right now and you're dealing with a situation at work, maybe you're having a hard time with your boss, maybe your employer is giving you a hard time about any particular reason, maybe you're having a difficult time with a colleague, maybe you've been let go from your job or laid off from your job temporarily, and you're wondering what your rights are in any given situation. This is the time, this is the place. If you're struggling with any issues at work, go ahead and post your question right now. Again, this is a live employment law Q&A. I promise I will get you on track to getting your workplace problem resolved. Again, whether that's an internal problem within the company, how to handle a situation, how to respond to your boss if you feel like you're not being treated properly, or certainly if you've been let go from your job, or again, if you've been temporarily laid off from your employment, or if there are any major changes happening at work, and we'll get to what an example of a change like that could be in a sec. Those are situations where you absolutely need to speak with an employment lawyer as soon as possible. Certainly when it comes to changes at work, when it comes to temporary layoffs, or certainly when it comes to being let go from your job. Rule number one, of course, our longtime viewers and listeners will know this quite well. Do not sign anything on the spot. Rule number two, and this is the cardinal rule, make sure you speak with an employment lawyer about your situation as quickly as you possibly can. And again, this is a live Q&A, so now is your opportunity to go ahead and ask your question. Speak with an employment lawyer directly. We can get you on the road to resolving whatever issue it is that you are having at work, even if it's a severance question. More than happy to answer any questions in that respect. A topic I wanted to get to today, just to get us started and warmed up and thinking employment law, wanted to talk about a situation, and we are seeing it unfortunately more and more, where businesses are sold. So a business is bought and sold, and the ownership of a company or a business changes hand. What are your rights as an employee in those kinds of situations? But first, wanted to give you a couple of pieces of contact information. You see our website address on the screen right now. It's www.employmentlawyer.ca. Great resource for you. If you're perhaps a little too shy, a little too bashful to go ahead and post a question, and you shouldn't be, by the way, but if you are, go ahead and visit our website. We've got a ton of resources on the website online as a starting point. We've got an employment law essentials page that'll give you the basics of an employee's rights in Ontario when it comes to things like changes in the workplace, severance, temporary layoffs, being treated properly in the workplace, issues of harassment and bullying in the workplace we address on that webpage as well. We've also got a ton of articles, blog posts, video clips of all of our lawyers speaking on various employment law issues that come up in the news from time to time. If you want to get a hold of us, our email address, very easy, very simple. Go ahead and send us an email at help@employmentlawyer.ca. It's help@employmentlawyer.ca. Again, you see it on the screen right now. Go ahead and email us at that email address. Give us a brief description of the situation that you're dealing with. And I promise someone will get back to that email. We have an entire team of intake staff standing by to field questions, provide initial information, put you in touch with our employment lawyers, and again, get you on the road to resolving that workplace issue. Okay, let's get into the topic today, folks. I guess to get us thinking and talking employment law. Wanted to talk about when a business is sold and what rights employees have in those circumstances. If you're just tuning in right now, my name is Alex Lucifero. I'm an employment lawyer with Samfiru Tumarkin, LLP. We are the employment lawyers, particularly if you're listening or viewing us right now in the provinces of British Columbia, Alberta, and Ontario. We are able to assist you with whatever your workplace issues are in those provinces, do not be shy to reach out to us. Do not be shy to give us a call at the office. If you're dealing with a difficult situation at work, it's not a situation that you want to let fester. It's not a situation that you want to operate in blindly. You need guidance, you need advice, and the person that you get that advice from is an employment lawyer. So again, don't be shy to reach out. All right. What are employees' rights when a business is sold? So this is a situation where one of two things are possible for employees whenever there's a purchase and sale of a business. And it's quite binary, in fact. It's certainly possible, and I would say even likely, that whenever there is a transaction and a business is purchased and sold and new ownership comes into being at a particular business, it's very likely that you as an employee, your employment will simply continue through that purchase and sale. So from day one to day two, there may not be really much difference if ownership of a company changes. You could be doing the same exact job that you were doing one day with one particular owner and doing the exact same thing the following day with that new ownership group. And if that happens and your business, your employer is purchased and sold, and you're not asked to sign anything, you're told that your job is going to be remaining the same, and nothing changes except for, again, the owners of the company, then there's probably not much to be worried about there. One of the main questions that employees will have in those circumstances is, do I start as a day one employee with these new owners? Is it kind of new employment because the company's changed hands? And the answer is unequivocally no. You do not start as a day one employee. All of your years or months of service carry over from the previous owner to the new owner. So if you were a 10-year employee when your employer is bought and sold by a new ownership group, then you continue to be a 10-year employee. A new owner doesn't get to wipe the slate clean in terms of years of service for all of its employees. All of those previous years of service carry over from the previous ownership group to the new ownership group. That should be obvious to many. If it's not obvious, well, then I've just made it as crystal clear as I possibly can. Years of service carry over in employment from one owner to the next. You do not start as a day one employee just because your company has been bought and sold. That should be the easy one. The other thing that ongoing employees, so if you transition through that purchase and sale of the business and you continue to be an employee, something that we see very, very often is that the new owners of the business, the group that has, or the individual for that matter, that has purchased the company and taking over the business, oftentimes they will introduce new employment contracts to existing employees of the company. And that is a red flag for employees. And I would say, regardless of the situation, but particularly when we're talking about businesses being bought and sold, when an employer introduces a new employment contract to an employee, to an existing employee, be cautious as an employee not to simply and blindly sign that contract without taking a look at it, a very close look at it, with an employment lawyer. Because I guarantee you, in the context of a purchase and sale, the new owners, the purchasing entity, will introduce employment contracts that give the new ownership group extra rights, extra protections, and that may very well limit your rights and limit your protections as an employee moving forward in your employment with that new owner. I'll give you a couple of examples. A lot of times we will see new owners come in and offer employment contracts that limit the amount of severance that employee is going to be owed moving forward. They may even also introduce terms that allow the company to temporarily lay you off moving forward, or that allow the company to make changes to your employment moving forward without your consent or without even providing advance notice. So the other thing to be very, very careful of here, if you're an existing employee and your company is being bought and sold, and your employer has, and the purchasing entity has introduced new employment contracts. Listen, even if those contracts come with a raise, even if those contracts come with a signing bonus, Pay special attention to all of the additional terms of the contract. Odds are that new owner is going to want to protect itself in terms of the severance that it's owed and give itself extra rights, extra protections in terms of what they can do to those employees before you sign any kind of employment contract. Certainly in the context of a purchase and sale of a business, but even at the start of an employment or during any kind of employment relationship, make sure that you have that employment contract reviewed by an employment lawyer. Do not blindly sign off on an employment contract without understanding fully and completely what your rights are in the circumstances. Because if you sign that contract and a week later or a month later or a year later, even your employment is terminated, well, that contract, again, it may limit the amount of severance that you're owed. It may allow the company to do things that you don't want that employer doing to you, like temporarily laying you off or like demoting you, as another example. So be careful as an existing employee. If your company is going through a purchase and sale, be careful when you're offered an employment contract. Even if it looks tempting to sign on the spot, make sure to take some time to review it thoroughly and review it with an employment lawyer. Now, last point here we're talking here about rights that employees have when a business is sold or purchased from the other perspective. It is certainly possible, and our concern here at Samfiru Tumarkin LLP is that we might see a rise in either business closures or businesses being sold as a result of the general state of the economy in 2025, what we're seeing with potential tariffs from the US. There might be lots of turmoil here in terms of business operations and expenses, and that is unfortunately going to mean changes to lots of employees' employment. If you are let go as a result of a business being sold, or even, I would say, as a result of a business closure. So if a company decides to cease operations, and I'm not talking about bankruptcy here, I'm talking about you losing your job because a business has been sold or because a business has simply decided to stop operations, to cease operations. The good news in an otherwise very difficult circumstance, obviously no one wants to lose their job. But if you were a non-unionized employee, let go from their job as a result of a business closure or a business being sold, the good news is that you are owed the same amount of severance that any other employee would be ordinarily owed in the circumstances based on your age, your length of employment, and your position within the company at the time of termination. The older you are, the longer you've been with that same employer, again, counting previous years of service as well with a previous ownership group, and the more specialized or certainly the more senior your position is within that company, the more severance you are going to be owed. Severance is not just a couple of weeks per year of service. Severance could be as much as 24 months of pay, 2 years of pay for employees let go from their jobs. Certainly, if we're dealing with a difficult economy, you're going to need every single dollar of a reasonable and fair severance package in order to hold you over until you can find new employment. Do not accept a severance package without speaking to an employment lawyer first. Make sure you know what your full severance entitlements are based on your age, position, and years of service. We've got a nifty tool for you that you can use, and you might have seen the website on the screen a few seconds ago. Pocketemploymentlawyer.ca is where you can go to get some basic questions about your employment rights answered, and also to calculate your severance entitlements. It's completely anonymous. It's completely free, perhaps most importantly. And if you're wondering, even if you haven't been let go from your job, if you're just curious what your severance entitlements are if you're ever let go, go ahead, visit pocketemploymentlawyer.ca, input your age, your length of employment, your kind of approximate position within the company. Are you management? Are you a technical employee? Are you a laborer? Are you senior management? Insert that information, that very basic confidential information into the website, and you will get a very good idea of what your severance entitlements are going to be. Severance, again, is very, very significant. Even if you're a short-term employee, by the way. Even if you're a 1 or 2 year employee, severance could still be several months. We very often see situations where a 1 year employee is going to receive severance in the range of 3, 4, 5, maybe even 6 months of severance, not weeks of severance, months of severance. That's just one example of how significant an employee's severance entitlements are in Ontario in particular, but across Canada more generally. So hopefully that helps some of you out there dealing with situations at work where maybe your employer is being sold, maybe your employer is struggling and closing down and shutting down operations. Understand your rights as an employee if your employment is going to be continuing. Understand your rights as an employee if your employment is coming to an end. There's going to be a hefty severance payment there to be had. All right, let's get to the questions, everybody. You've been very patient here. Wanted to talk about this subject because it's one that's come up quite frequently. But this is a live Q&A. We've got a couple of questions lined up already, which is great, and we'll get to them right now. But if you're just tuning in, please go ahead and post your question right now on whatever platform you're watching this on. Of course, you can keep it very brief, keep it very generic. Don't mention your particular employer, your specific name. Keep it very general, and I promise I will get you on the road to resolving whatever workplace concerns you have, even if it's a question about maybe your pension entitlements, or a question about what kind of severance you might be owed, or what options you have if your boss is trying to force you into a change at work. Again, go ahead and post it, and I promise I'll get to it before the end of the segment. We've got about 14 minutes left here for now. All right, let's bring this up here. First question on YouTube. I am a salaried employee. My employment contract, in my employment contract, that is, I agreed to 35 hours a week and no mention of overtime. Currently, I'm being expected to do a minimum of 1 hour of overtime every day and getting paid for the overtime being done. But would rather just not do it at all. I've spoken to my manager to clarify whether this overtime is just company expectation or whether it's a contractual obligation. Can I be mandated to work beyond the 35 hours a week that I agreed to in my contract? It's an excellent question. The question is from Due Possession, which is a great name on YouTube. And the answer to the question is as follows. The short answer is no. If you clearly agreed to a 35-hour work week in your employment contract, and for whatever the reason might be, you're either unwilling or unable to work more than that, you are well within your rights to tell your employer, I'm sorry, I can't work those extra hours. 35 hours is what we agreed to. It's in the contract, and that's all I'm able to work. Due possession, there is absolutely nothing wrong. You cannot be punished. You cannot be reprimanded. You cannot be disciplined for holding the employer to the terms of the contract. If the contract says 35 weeks, then 35 weeks it should be. I will add this, however, maybe this is the other side of the coin, Due possession, that you need to consider. If you are a non-unionized employee, do keep in mind that at the end of the day, an employer can decide to let an employee go really for any particular reason, as long as that reason isn't discriminatory. And so your employer cannot let you go because of your age, for example, or your gender, or your religion, or a potential disability, right? Your employer cannot let you go for those reasons. But if your employer decides to let you go because you're unwilling to do that 1 extra hour of overtime, well, then that is perfectly legal. It is well within an employer's rights to make that decision that, you know what, this isn't working out. This employee doesn't want to work that extra hour. Let's make the decision to let them go. Again, there's nothing inherently wrong with that. Of course, there would be a severance obligation there, due possession. So your employer would owe you severance if they did decide to let you go for that reason. But if you can't agree on this issue, right, and there's no other ground of discrimination that the employer is basing their decision on, right? So again, if it's not discriminatory in any way, your employer can decide to let you go on this reason. You have to consider that as an employee. How much do you want to play ball if really all we're talking about here is an extra hour of work, versus how much are you willing to fight this issue and stand on that hill and potentially die on that hill. That's something for you to decide based on lots of other factors, of course. How much do you generally enjoy the job, get along with your employer and your colleagues there? How well or not are you being paid? Lots of those issues, of course, come into play. So you certainly have the right to say no, but your employer can then make the decision that, well, you know what, this isn't working out, and decide to let you go for that reason. So keep all of that in mind. Due position, of course. If you'd like more information, if you'd like to discuss this in more detail, I'd be happy to review the contract for you. If you'd like, go ahead and give us a call at the office or send us an email at help@employmentlawyer.ca. More than happy to have a chat with you in that respect. And again, answer any other questions you might have. All right, next up in line is Ocean Breeze on YouTube. Ocean Breeze 2022 asks, an employee whose regular work hours are 8 hours, 5 days a week, it's 40 hours, folks. They've asked for accommodation to be taken off the on-call list. Can an employer force the employee to go on disability insurance because of this sort of arrangement? An employer cannot, in no way, shape, or form, force an employee to go on disability insurance. It is ultimately up to the employee's doctor or treating physician, whether that's a family doctor or a specialist, whomever it might be, it could even be a physiotherapist for that matter. It is up to that medical professional to decide, A, whether that employee is able to work or not, and then B, to what extent they can work or not. So Ocean Breeze, if what you're implying here is that you can only work a maximum of 40 hours a week for medical reasons, and you don't want to be on an on-call list to have to work extra hours or perhaps different hours as opposed to your regular 5-day-a-week schedule, here's what you do, and here's all that you have to do. Go ahead and get a doctor's note from your doctor, from your medical professional, saying that you are only able to work 8 hours a day, 5 days a week, and that you cannot work any time beyond that. Your employer has to respect that medical professional's opinion. They have to abide by what accommodations your medical professional is giving the employer. And your employer basically has to accommodate you in that respect. They can't just put you on medical leave or put you on disability insurance just because it's inconvenient or it's uncomfortable that you can only work a certain amount of hours. That is a failure to accommodate in the eyes of the law. It's a human rights violation in Ontario. Your employer has to accommodate your medical restrictions and limitations to what's called the point of undue hardship. Undue hardship for an employer is a very high bar. It has to be near impossible for an employer to accommodate you in order for them to say no and say, no, we need another solution here. So if all of this is, Ocean Breeze, is you being limited in the amount of work that you can do for medical reasons, get a doctor's note, give that doctor's note to your employer, and they have to play ball. If they don't, give us a call at the office. Let's have a chat. We can either extract you from that situation and get you your proper severance entitlements, or we can contact the employer and resolve the issue probably quite easily, because the law is very clear when it comes to medical accommodations in the workplace. All right, guys, appreciate all the questions. Let's speed it up here as we have about 5 minutes left. All right. Han on Facebook. Han asks, how and where can I complain anonymously about unhealthy workplace conditions? We've had a leaky ceiling for at least 4 months. This is water leaking from a bathroom, so it might even be contaminated. I work in a really old building, so ventilation isn't great anyway. Management just keeps putting it off, saying maintenance will look at it, but it's been this way for 4 months now. Han, great question, important question. Health and safety in the workplace is of utmost importance. Han, it depends on the nature of your employment. And maybe to put it simply, I would say it depends mostly on whether you're unionized or non-unionized. If you're a unionized employee, Han, speak to your union as soon as possible about this. You might have mentioned it to your manager, you might have mentioned to the employer, but if you are a unionized employee, your union needs to know about it, and they can force the employer to take action. It could be in the form even of a grievance against the employer as a result of health and safety concerns. Now, If you're a non-unionized employee and you've brought this issue to your employer's attention already and they haven't done anything about it, certainly if you're in Ontario, but in any other province as well, you've got to contact the Ministry of Labor for your particular province and report this as a workplace health and safety concern. Again, in Ontario, that would be the Ministry of Labor. It would be brought under the Occupational Health and Safety Act, and the Ministry of Labor will appoint someone to investigate your concerns and then take action. You can also potentially speak to the company's HR about this. So if your particular manager or certain people in management haven't listened to you, report it to HR and as a health and safety issue. And this way you can at least show that you've done your due diligence by contacting human resources, even though, of course, management is already aware. All right. Breezy up next asked, how successful is sending a demand letter to previous employer? A demand letter is effectively just a letter from a lawyer asserting certain rights, for example, severance, if it's going to be an issue that's severance related, and proposing a settlement or a resolution to that particular issue. I've got to say, Breezy, the success rate is relatively high. Most employers, when they're dealing with an employment law issue, will act reasonably, will engage in discussions and negotiations, and will be reasonable in reaching some sort of fair compromise and solution between an employer and an employee. Some employers, however, unfortunately, are much more difficult to deal with, much less keen to be fair and reasonable to employees, and that's sometimes where such letters might not be as much use, and more aggressive forms of legal action need to be taken. All right, 3 minutes left and 3 questions left. So let's take these a minute each. Thanks everybody for tuning in. By the way, hopefully you found some of this information helpful when we're talking employment law, when we're talking workplace rights. There's lots out there to know, and the more information you have in that respect, the more armed you're going to be to deal with any workplace issues or workplace conflicts that come up. Case in point, Renee French asks, if you're misclassified as an independent contractor, but you were responsible to pay certain expenses, such as gas and truck, and you're getting paid 100% commission, how do you determine your earnings? Renee, it depends what purposes you're determining these earnings for. Of course, if it's for income tax purposes, you're going to have, of course, your earnings, your expenses, and then whatever profits you might have after the fact. If we're talking about a severance claim here, Renee, then it's the commissions that it's going to be calculated on. That's certain, particularly in a situation where if you've been let go from your job, of course, you don't necessarily have those expenses anymore. And so your earnings from the employer is the loss that you've suffered as a result of the termination of your employment. I make that point to say, even as an independent contractor, as a contractor more generally, number one, oftentimes you may be labeled an independent contractor, but you are in fact an employee of the company, in which case you are owed severance. But even more than that, even if you are well and truly a contractor, if you are what's called a dependent contractor, meaning you work for one entity and one entity only, you don't have several clients or several businesses that you work for. If you work for one company only, even as a contractor, you're going to be owed severance from that employer. And so lots of independent contractors and contractors more generally also have severance entitlements that need to be determined and calculated and that they're owed. Silver Star asks, can an employer reject your application if you left previously and quit your job? Is it standard practice? Silver Star, as long as the decision to reject an application is not discriminatory. And when I say discriminatory, and by the way, I'm talking here specifically about within Canada and within the province of Ontario, as long as that decision isn't based on protected grounds, such as your age, your religion, your gender, your nationality, etc., then yes, your employer can reject an application. They're well within their rights to, for whatever other reason that might be. They might not like the color of your shoes, as a silly example, and that wouldn't necessarily be illegal. Illogical, of course, but illegal, no. All right, last question. Ronald asks, my employer wants me to sign a new contract after 12 years on the job. Is this a good idea for me? I'm worried. Ronald, I don't mean to be alarmist here, but you should be worried. It's always a red flag when your employer is asking you to sign a new employment contract, especially mid-employment. I guarantee you, Ronald, there are going to be terms in that contract that limit your severance, that limit your rights as an employee. You're right to be concerned. That said, we don't have to necessarily ring all of the alarm bells. Just make sure you speak with an employment lawyer about the contract, especially as an existing 12-year employee. You're going to have some leverage in the situation. You're going to be able to negotiate some of those terms in the contract. Give us a call at the office. Let's go over the contract. Let's make sure what's good, what's bad about it, and figure out a path moving forward, how to respond to your employer as far as that contract negotiation goes. Folks, you've been great today. All great questions. It's been a pleasure. Time flies when we're answering questions about employment law. Wish you all a great rest of your week. Tune in tomorrow for another live stream with my colleague Dan. If you haven't been able to ask a question today, Dan will be able to answer that question. Until next time, everyone, have yourselves a great day. Take care and so long.